Hi there, everyone. Thank you for joining us today. I'm Marcia Butler, the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We're thrilled to bring you today's educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box. The presenters will answer those queries during or after the webinar today as appropriate. If you ask a question in the chat box, go ahead and leave your phone number as well. If we can't get to your question during the event today, we'll make sure someone reaches out to you after the webinar. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. Well, I'd love to introduce you to our panelists today. And here are their pictures here. Our moderator today is Eric Maldonado, who is the owner and founder of Aquila Wealth Advisors, LLC, in San Luis Obispo, California, which was established in 2017. Eric has over a decade of experience providing financial planning and investment advice. He is a fiduciary financial advisor and a fee-only financial advisor. That means Eric and his team work under a fiduciary standard of care, putting their clients' interests first, and their compensation method is the most transparent and objective method available. Eric earned his MBA master's degree in financial planning from Indiana Wesleyan University and his bachelor's degree in business administration finance from Cal Poly San Luis Obispo. In addition, Eric has designations of certified financial planner, practitioner, certified exit planning advisor, and certified kingdom advisor. And I will go ahead and let Eric go ahead and say hello so we can see your face. And
hi, Marcia. Hi, everyone there. Excited to be with you again, Marcia, and looking forward to talking about such an important topic as estate planning, wills, and trust. And a lot of times it's complex and confusing. So it's a real treat to have Matthew here with us, and looking forward to getting after it.
Excellent. So we're going to go ahead and introduce our speaker today. Matthew O'Leary is a founding partner of O'Leary Wallace, LLP. Currently, Matthew practices trusts, estates, and elder law with an emphasis on special needs planning, conservatorship, and probate and trust litigation. Matthew has resided in the Central Coast since 2010. Before founding O'Leary Wallace, Matthew was an attorney at the estate planning law firm of Stephen K. Hall and Associates. He also worked for a boutique civil litigation law office in San Jose, California, served as a law clerk for the Santa Clara County and Santa Cruz County District Attorney's offices, and held a judicial clerkship in the Family and Probate Division of the Sacramento County Superior Court. So Matthew, I know we've done a lot of preparation, and we're really excited to hear what you have to say today. I'll turn the time over to you now.
Well, thank you so much, Marcia, and thank you to Advice Chaser for having me, and thank you to you, Eric, for being today's moderator. I appreciate the chance to be here, and I appreciate getting to talk about estate planning because I am a nerd about these things, and once in a while, what bores someone else, I find fascinating. So what you just saw briefly on the screen there was the standard lawyer disclaimer. That's because what's a lawyer without a disclaimer? All that disclaimer says is that I am going to give you the best, most accurate information that I can today. I'm not your attorney based on this conversation, at least. So please don't tell your probate judge or your brother that you now have the legal answer that you got from your attorney. But that being said, I am going to try to give you the best, most accurate, relevant information that I can. So today's topic, well, everyone needs their own estate plan. And I phrase it that way because you'll hear me say it a few times, is that you have an estate plan, whether you know it or not. There's rules that are going to be implemented on your affairs, and what estate planning is, or at least from our vantage point, is it takes the opportunity for you to take control of those decisions and to make a plan that fits your needs and your life, as opposed to a plan that's going to be subjected upon you if you don't make these decisions for yourself. So one of my questions I get with new clients, or perhaps I get them when I'm talking with someone at a dinner party or something, they'll make a joke, or they'll say something like, well, once I have an estate, that's when I'll come see you fancy estate planning lawyers. Ha ha ha. You know, when the business takes off, or once I've gathered up enough money, then I'll think it's worth it to have an estate plan, because then I'll have an estate. And I'm not so annoying as to correct them at a dinner party, but I do try to point out that your estate doesn't mean your millions and millions of dollars. Certainly includes that if that's you, but it means a lot of other things too. Your estate's an accumulation of everything that you own. We listed your car, your real estate, your checking account, savings account, your furniture, your life insurance, the jewelry that you got from mom or grandma, the artwork that your kindergartner gave you and it's still on your refrigerator. But it also can mean your right and ability regarding healthcare decisions. It could be your access to credit cards, your mortgage statement, your utilities. It can be all types of things that literally everybody has, and everybody should plan for in a way that it can be controlled. And it doesn't just mean our millions of dollars, though it certainly includes that too. So, do you have an estate plan? You heard me mention it. There are certain default rules that the state of California, which is where I practice, or the state that you're in, are going to prescribe for you if you don't make a plan otherwise. And those rules might be fine. I'll point out some areas later where they're definitely not fine, but the general plan that the state has for you might be exactly what you have in mind. And so you might be one of those people that you benefit from estate planning, not because you want to do something so divergent from what everyone thinks the default should be, but you still want to make it easier, more straightforward, and frankly, less expensive by coming up with your own version. So some of these default rules that I mentioned, this slide references incapacity. I'll start there, but then I'll tell you some of the other default rules that we have. So one, you might have heard the host mention, I practice what's called in California conservatorship law. In other states, it's referred to as guardianship law. Sometimes it's called guardianship and conservatorship law. But what I do is I make decisions or help families get in place to make decisions for folks that can't make decisions for themselves anymore. And so that's the default, is that if you're incapacitated, you're unavailable, you're laying on the hospital bed, unable to speak, no one gets to just jump in and help you. Not even your spouse, not your kids, not your parents, not anybody in that circle around you that might be incredibly well-intentioned, and mostly they are. Those people that would have your best interest at heart, without a doubt. All of those folks are stuck. They can't jump in and help because the law says, and you can probably figure out why, but the law says that if it's not you doing it, if you're not making the decisions about your affairs, no one gets to do it without first going to court and getting a court order that says you're not able to anymore, and now somebody else can for you. And because that's a pretty dramatic showing, that's something that takes a lot of time. It takes a lot of man and woman hours to bring to court, to have the court hear it, to gather the information. So that can be very expensive. And so all of that, almost all of that, that tough, difficult, long, expensive experience can be avoided with some simple estate planning tools. Some other default rules, though, are where does your stuff go? Perfect segue, Marche. That's in California, it's called intestate succession. That's going to be consistent most places. It's going to be something to the effect that out here in California, we look to the next of kin. So if you're married and you have community property, everything goes to your spouse. If you have separate property, meaning property you had before you got married or property that you got later, and half of it's going to go to your spouse if you have one child or just extended family. If you don't, if you have more than one child, 1/3 of it's going to go to your spouse, 2/3 going to go to your children. And then from there, it breaks down further. It says, okay, if you have no spouse, but you have children, it goes to your children. If you don't have children, but you have grandchildren, it all goes to your grandchildren. If you have no children, but you have parents, it goes to your parents. And then it starts to get a little tricky because it breaks out to siblings and issue of siblings. And then from there, the spider web grows. One of my more lengthy cases, I was hired by a company that finds heirs throughout the country. And there was a person who passed away over in a coastal community here in California. And a cousin said, okay, I'm the only heir and I get her house that's worth about $1 million. And my company that brought me in to help a bunch of people found out this situation and did the genealogical tree that traced it all the way back to England and back down, and found 72 heirs with all various standing. Some of them, my favorite part about it is that 2 of them were nearly neighbors in Illinois. They lived like 2 blocks apart, had never met each other, had no idea that they were related. So that's very interesting, of course, but that's also probably not what the gal over here in the coastal community who passed away wanted. She probably did not care whether a cousin that she literally didn't even know existed inherited from her or not. She probably wanted it to be the guy who said, I get everything. So those default rules might not be best for you. Eric, is there a question on that we should answer now, or is that something for later?
Yes, we have some questions coming in, and that's actually a good plug. If you have questions and you're listening live, feel free to bring them in, and we'll I'll share them as we go, or we can save them for the end if maybe they're not relevant at this time. But one question we have, Matt, is it important that your estate planner is in the same state, or your lawyer is in the same state that you reside in?
And that is a really good question. Yes, in the short answer, yes. Are the rules generally the same? Absolutely. But there are wrinkles in every jurisdiction. Some wrinkles are bigger than others. And your attorney should be licensed to practice where you are. So there are times when I have clients that are out of state, but that's because it's involving a California real estate situation. So in general, I would make sure that you see an attorney at least within your state.
And then speaking on the real estate conversation, someone has a question. If you have your house with your spouse, you owned a joint, but then you have another house that you own, how does that then get bequeathed or get split up to your heirs?
That's a great question. And what in California we describe as community property versus separate property. In some other states, they call it joint property, and then they have a joint versus community property designation. But the idea is that in California, at least, separate property is your stuff that you had before or that you got through a separate property source. Community property, the default rule is what you earned while you were married. Now, if you don't have a spouse, if you aren't married, but you have a significant other, that person has no legal standing to inherit from you at all. Now, there are other jurisdictions. California is not one of them. I had a law professor tell me a reason. We don't have common law marriage here. So you could live with someone for 50 years, never get legally married, and you have no direct standing to inherit from that person. My law professors theorized that there's no common law marriage because that was something that a little bit more of an old-fashioned rule, and it here early on, California with the Hollywood powerful scene had a lot of cohabitations that weren't marriages, kind of leading that charge. And so we abandoned common law marriage as a state quite some time ago. So that's if you have a significant other who's not a spouse and you want to provide for them, very important that you take care of that in your estate plan, because the default rule will be that it will absolutely not go to them at all. And it, like I described with the 72 heirs, it might be with people you don't even have a connection with.
I will say we are getting more questions, and we're going to hold some of these to the end. I think, Eric, you and I agree there. We want to make sure that we get through the content, and we'll try to answer as many questions as we can as we go forward.
Yeah, absolutely. Really good questions coming in.
And definitely, Eric, don't hesitate to interrupt me if one pops up you think is extra applicable to whatever we're talking about.
You got
So
it.
we were talking about default rules about who gets your stuff. Default rules about what happens if you're incapacitated. Kind of continuing more of that incapacitated thought. The default rule regarding healthcare. Raise your hand if you've ever tried to call the doctor's office just to talk about your spouse, or you get a bill and they say, "Oh, I'm sorry, we can't give you that information." So there is a limit to even between spouses, even to, often happens, parents with adult children who've just come of age. There are all these limits, well-intentioned, like many of these rules are, well-intentioned, that a doctor's office isn't going to give away your information without your express permission. And that can become very burdensome in a spousal situation or a joint household, become very burdensome if you're unavailable, can't speak for yourself. If you need an advocate, people, again, they like to, they usually know what's best. And so there's a tendency to kind of let that stuff happen, but they don't have to, because the law actually says they shouldn't. HIPAA is a federal law, and it gives a penalty that doctors' offices pay if they give out someone's medical information. So they're often apt to not want to give this out. So the default rule is that nobody gets to speak for you. And that's a rough situation to be in. I know for sure that if I'm going under the knife or I'm unavailable, I want my wife and my mom to both be the advocates that they are, to try to make sure that I'm getting the best coverage and the best service and the best treatment that I can. So make sure that default of no one speaking for you doesn't apply. The other default that is a little more tough to think about, but is really important to a lot of people, is that there's no, if you want to be let go, if you're being sustained artificially, if you're on life support and that's the only thing keeping you going, and as I say in my documents, you're not returning to cognitive functioning existence, very, very few people have ever told me they don't want to then have that life support discontinued. But if you don't put that down in your document, the default rule says we're not going to do that. Again, that's well-intentioned, of course. We don't want to run around unplugging people's medical treatments simply because, we think their time is up. But the default might be very financially burdensome, might be very emotionally burdensome, to be stuck in a spot where you're being kept going artificially, and you would much rather be released from that. So that's something that needs to be in your documents if that's your decision.
Matt, how does someone understand all the scenarios to be able to know which one to choose from? Is that what an estate planner does? Gives you each scenario, like, for example, the incapacitated one, speak to in your documents? Yeah. And your doctor's office often has some templates for you. The California Probate Code actually has a copy of what we call out here an advanced healthcare directive. Other states call them power of attorney for medical treatment, etc. A lot of states have followed suit to have, like, it's essentially what is a generic version of the document that anybody could pull up and use. The document that California uses is very binary. So it says, I want to be prolonged as long as possible. I don't want to be prolonged at all. Shut it down.
and it doesn't leave a lot of nuance. So, I prefer our documents, and I'm sure most attorneys would say that they like theirs with a little bit more middle space and discussion about what means what. But check, start with just looking in your, if you write the right search terms, you should be able to find that on an internet search of your state's probate code. Might have a healthcare directive that you could look at right now if you wanted.
Nice. That's good.
So, yeah, why do your own version? Why not have the state's version for you? And really it comes down to control. And so that can be something that's, some folks go, yes, control. And other folks say, ooh, control, that sounds like a bad word. But the idea is not that you're pulling all the strings like the puppeteer. It really means that you're taking some of the fear or the negative parts of a tragic event or an eventual certainty of us all passing away. Forgive me if you've never heard that before, but that's where we're all headed. But it takes that fear, that negativity out when to some extent, when you've been able to plan for it and put it in the best way possible. And so this control that I'm talking about, again, it's not an overbearing manipulation. It's a structure that allows for the best case scenario for you and your family.
That's good. Matt, we had one question on going back to the medical. If someone designates a person, and they're not available, let's say you designate your spouse and they're not available in like a medical situation, how does a doctor figure that out?
Gosh, that is such a good one. Yeah, and it's that's a messy world, so it's hard to know exactly how that would go. A document that either your generic version from your probate code or definitely one that an attorney prepares would have a backup, and maybe it'd have 2 backups or 3 backups, and then typically it would have a succession plan. So it says, is your spouse just on a hunting trip for the weekend, or is your spouse 10 years predeceased, or is your spouse in the hospital bed next to you? And how do we get to that next person in line? If there's no one named in that document, because let's say you did it 10, 20, 30 years ago and the choices aren't relevant anymore, or that person's passed away, all of a sudden, because we didn't use our opportunity to plan and take control, we're back to those default rules about a conservatorship or guardianship or some sort of laborious, expensive court proceeding that we definitely want to try to avoid. So that's a really good question.
Yeah, that's good. And on the topic of kind of tragedy or things like that, this is a question about someone being married. They have kids, they do a trust, but then their spouse deceases and they get remarried. Does that new spouse, are they automatically like entitled to anything, or do you have to update the trust? That's a widow or a widowed situation.
Yeah, that's a good question. In California, the default rule is that if you get married to someone and you don't update your estate plan, the law presumes that you meant to do it, you just never got around to it. And so the law will implement a omitted spouse share, which is that community spouse separate property share of the estate. And that might be exactly what you had in mind, or going back to our idea of control and planning, that might be not at all what you had in mind. It could be either end of the spectrum. Like if that's not nearly enough, or that's way too much. So that is a reason why if you get remarried, you need to revisit that plan.
It's good. It's good info. Thank you.
All right. So I keep hinting at all these different documents, but let me tell them, a little bit more expressly. When I'm talking about having your own estate plan, what documents am I talking about? We'll start with the most final one. That's your will. So everyone's at least heard of the term. Doesn't mean everyone's had one. I think actually, 45% of people don't, but the one that's most common or referenced maybe is that will, or I always call mine last will and testament, but they're called a variety of things. A will is a letter to your family and hypothetically to a judge in your probate court that says, do this with my stuff after I am gone. So it does not mean anything while you're alive. It means maybe have an idea of what you want, but it does not affect anything while you're alive. If you're laying in a hospital bed, unable to speak for yourself, the will doesn't help. If you're, I get people sometimes who come in and they say, I was in mom's will and then it was changed. Don't we have a case? And, barring there's not other factors that go into that. No, you don't have some sort of status or standing just because you were named in a will. The thing I point out to clients out here in California is that the will does not avoid a court proceeding. Are there jurisdictions where it does? Perhaps. I don't know in the state in all 50 states. I know in other jurisdictions there's places where maybe like a professionally done will avoid a court proceeding. But out here in California, a will does not, so long as your estate isn't really small. And the reason why so often we try to avoid probate or an actual court proceeding regarding your will is out here in California is that it's an expensive, slow process. It takes about a year. I'll talk about this more later. It's public, and the average fee is $23,000. $23,000 to the attorney, $23,000 to the representative, about $5,000 in related court costs. So it's a $50,000 year-long experience for your family.
That's good. That hits home. That helps people realize, what the value is. Obviously.
Yeah. So there are advantages to doing a probate, and I like to point those out because it's a system that was designed to make sure there's an orderly process. If we didn't have that system, your neighbor dies, you move into their house, who's going to tell you otherwise that it's not? So it's a way to orderly make sure that, first of all, that the transfer of property or things from one person to the other is fair and legal. It's also a way to make sure that creditors both get paid, but also don't have forever to come after a person who's passed away and their family. They have a much shorter, more limited amount of time to make sure that happens. And I had a judge, the third point here, this bullet point, distribution is supervised. A judge just told me in the last couple of weeks, O'Leary, we're going to do a presentation and you're going to say why everyone needs a trust. And then I'm going to come in and say no one should have a trust, so that you all have to come before me and I'll make sure it's all done right. That's what the judge said. I'll have you know, he's retired. He's only there temporarily. He doesn't actually want that. But it's a plan. It's a way to be the distribution of supervised, meaning it's subject to court oversight. And so hypothetically, it's going to be done as close to according to the law as it can be. And so that can be a positive thing. I tell you though, I hinted at the downsides, or maybe I said them, but the downsides I think are worse. First of all, it's public. I do a presentation every year called Estate Planning, if you want to go back, Estate Planning Faux Pas of the Rich and Famous. And we talk about all these celebrities who died and what a mess their estate plan was. And the only reason I'm able to do that presentation is because if you don't do a proper estate plan, your estate ends up in court, and then nosy busybodies like myself get to look up and see exactly what you wrote down and exactly what's in your estate. And I get to see how much it appraised for. And if anybody files a complaint, I get to read all of those. It's all public. And that's annoying. It's time consuming. Like I said, it takes about a year. And that's just because of, court delay on this side, court delay on the back end, time frames for creditors and for getting accountings and appraisals all done. So it takes a while. And then I mentioned the really expensive part. $50,000 that some of it or most of it could have been avoided is usually worthwhile. So after a will, what's the next element of a personal estate plan? The next thing here in our slides is a trust. So folks tell me sometimes, like, I have a trust, I don't need a will. That's not necessarily true. You probably still need a will, but your will should now try to talk about your trust. So what's a trust? You hear about that all the time. What it is it's an agreement. It's an agreement usually with yourself regarding your stuff. You're looking in the mirror almost and you're saying, I will hold on to my stuff for myself in this contract. I'll be both sides. I'll be the person making the contract and the person agreeing to it on the other end to essentially hold it according to this contract. But because it's held in this contract, this agreement, it's like it was set up earlier, and now there's this rule and this plan that's in place that stretches on past your death. Could be generations past your death if it's done right. And so that lets that control aspect of thinking about different scenarios, thinking about exactly what you had in mind, and then trying to do your very best to set up a plan to avoid the bad and accentuate the good. It lets that plan get made, and then everyone is bound by that plan moving forward. Is there ways out of it? Sure, yeah, you can get court orders and things like that. But in general, when you have that plan in place, that contract, it lets us say, all right, state, you don't need to jump in here and charge us all that money and take all that time. We've already got a plan that's written out, and we're going to handle this person's affairs according to that plan. So it avoids probate. It gives you, when I say, does it guarantee results? I'm referring to two things. Yes, it's binding, but it also lets you do something like plan for the negative parts of the next, what happens to the next generation. So my favorite example of this is Marilyn Monroe left half of her image and likeness rights to her acting coach, some older man. She wrote that in her will. Half of my acting rights go to my coach, or image and likeness rights, and the rest of it, she gave it some to family and some to charities, animal related charities. Well, her acting coach, she dies tragically. Her acting coach inherits half of her image and likeness, and he then marries some young starlet, and then he dies shortly thereafter. And so Marilyn Monroe's acting rights and image and likeness rights were still producing in like the tens of millions of dollars, like 40, 50 years after her death. And it was all going not even to her acting coach's family, but to her acting coach's new spouse's family. And so, that's not a result that Marilyn Monroe had in mind. She wanted it to go to charity. She wanted to, she had animal related causes that she wanted to support. Sure, she had some family causes, and it skipped all of that and ended up in a place where she definitely didn't want. So that's the kind of result that you can essentially miss and guarantee what you really had in mind. It's private, so I get to know what Marilyn Monroe's will says because it's public, like I said. But if she'd had a trust, I have no idea. And then, can it save money? Sometimes, sure, there's horror stories that the trust is more expensive, but the vast majority of the time, it saves money on the back end. It costs more to set up. You go see an attorney where you are, there'll be some money charged. It'll be more than just crafting your will for you. But the back end savings is usually pretty significant.
On that guaranteed results topic, someone had a question about divorce, and if they're in the middle of a divorce, this is Pennsylvania in particular, so you may be able to speak to that state or not, but they're just wondering if you can disinherit your spouse in an estate plan.
Yeah, that's a really good question. Go see an attorney in your jurisdiction. But in general, you can disinherit your own spouse today. It's not good. It's not a good sign, right? It usually means there's something going on, but you can cut out your spouse today. That doesn't mean that you can give things away that belong to your spouse. So you might say, I can't give all of my home to my brother, but I might be able to give my half of my home to my brother instead of giving it to my spouse. And so, yes, you can do that at any point. You may not, there are rules about when you transfer property in a proceeding like that. So you may have some restrictions on whether you can make conveyances, like I'm going to transfer my interest in this house today. Got to be careful with that. But you can definitely sever joint tenancy, meaning like not have it go to them automatically. And you can definitely update your estate plan to provide for someone, anyone, and it doesn't have to be your spouse.
That's good. Similar to that topic of transferring property, does a trust automatically include all your assets? Do you have to transfer it in there? Kind of a
That's a
asset.
really good question, and I'll try not to get too into the weeds about it, but a trust is an agreement regarding property. It's an agreement saying I will hold this property for myself, or it will be held for future generations according to these terms. So it does need to be funded. If without any property, in its most basic, a trust isn't even valid. It has to have something. Which if you do a trust, or even come and do one here, one of the placeholders says something about $10 cash. People always laugh about that, but that's because a trust has to have some property in it. So we start with that. But so you do want to fund it. Does everything have to go into a trust? That really is fact dependent. For example, retirement accounts, like Eric, they can't be in your trust. They have to be in the name of the employee. There's other accounts that are similar to that. And so in which case we use beneficiary designations, or we use assignments of property. There's also situations where maybe the thing is not valuable enough to have to go through the effort to transfer it, because there's some non-probate court way to get it into your trust later if you passed on. And that's very jurisdiction dependent. Out here in California, we can have $166,250, very specific, $166,250 pass without a trust, without a beneficiary named, and not have to go through court. So it depends on where you are.
That's helpful. Thank you.
Yeah. So regarding trusts, and again, I'll try not to get into the technicalities, but I love the technicalities. So if you want to talk about them, let me know. We have trusts are generally revocable. That's when you see the name living in it, or you see revocable in the name. It's supposed to have one of those references. Sometimes you'll see family in the name instead of revocable or living. That's great too. But they're generally either revocable, which means they can be changed or revoked by the creator of the trust while they're alive, or they're irrevocable. They can't be changed, either without a court order, perhaps without some other kind of procedure that's set forth in a more complicated document. Most of the folks on this call and elsewhere, the right version for them is a revocable trust, because we want to provide maximum flexibility. We want this to be something that they did for their control, for their peace of mind, but it's in the background and they don't even have to think about it. It never gets in the way. But there is more advanced planning that sometimes requires the trust to be irrevocable. Special needs planning is very near and dear to my heart. And there are certain aspects of special needs planning that require the trust to be irrevocable. So it depends. And then the other thing that folks sometimes don't quite catch is that a trust is revocable by the person who set it up. And so all of those revocable trusts, with very few exceptions, are all irrevocable someday when the person who created it dies. So it might say the living trust, the family trust, the revocable trust, but if the person who created it is now dead, very likely that trust is now irrevocable.
That's good. This is going back a little bit to the states, but similar, topic of trust and estate planning. Someone lives in New York, for example, and they have real estate or, rentals in North Carolina in this example. Do they do the estate planning in both states? Does one state where they live?
I love that question. That's a great question. Generally, that's a great question. Generally, you'll do it where you are living, or sometimes maybe you'll do it in a jurisdiction that you think is more friendly to your situation. A lot of people use Nevada for that reason. But generally, if you live in New York, you got rentals in North Carolina, no problem. Do your estate plan in New York. Do the rest of your documents with your New York attorney so that they're making sure that as we're going to talk about next, your power of attorney, your healthcare, your wills, all that is done right. And then you will make sure that your North Carolina property is at least retitled, as if you conveyed it from yourself to yourself in the name of that trust that you set up in New York. And that is almost always perfectly fine, works out great. There's very, very rare situations where that doesn't work.
That's good. And on the similar vein of houses, someone asks, maybe you're going to speak to this, just pro and con of putting your house in the trust, like your own personal residence in the trust. Do you always have to put your own house in a trust? Should you?
Yeah, I mean, I don't want to speak for every situation in every jurisdiction, but it's hard for me to think of and I love coming up with weird hypotheticals, but it's hard for me to think of one where it would be a negative to have put your house in trust. You almost always would. And it almost always is the case that if you didn't, it was a mistake, and it's perhaps going to cost your family time or money in the form of a court proceeding to get your house into your trust. So very rare is the situation where you didn't put it in trust and that was on purpose. You will run into an issue with refinancing or maybe getting a mortgage where the mortgage company says, hey, wait a minute, even though you have that well done trust that gives you the power to borrow like they almost all do, we don't trust it and we want you to have it in your own name. So once in a while, you'll get a mortgage company that does that, and you'll have to go through the terrible burden of signing one extra document that transfers it out of trust and then sign one more document that transfers it back. But that's about the worst thing I can usually think of.
Yeah, some people within that scenario ask, well, are they going to call my loan due? Do I have to pay my whole mortgage at that moment? Never happened.
Man, these are good questions, Eric. That's a great question. There are federal regulations that say the mortgage company may not do that. So long as you are not changing the ownership percentages. So if you transferred it to your irrevocable trust that's very complicated, that you are not a beneficiary of, there's a chance, sure, the mortgage company could call your loan. But federal regulations say that the transfer from you to your revocable trust, they may not call the loan.
Nice. Good to know. Thank you.
Those are good questions. So we talked about a will briefly. We talked about trust a little bit. What other documents? Is that it? I got my will and I got my trust. Is that all I need? No. In fact, this document I'm going to talk about next, though not used as frequently as the will that we'll all use because we'll eventually pass, or the trust that some of us or many of us might need. This document everyone should have, and most of the time it won't get used. But when it is needed, it's so crucial and so important. If you don't already have a power of attorney for financial affairs, go do one today, or go get an appointment with an attorney. The power of attorney says that an agent can step into my shoes and carry out whatever important financial transaction that I need to do on my behalf. And that's usually about it. Usually says they can do whatever they got to do so long as it's helping me. So you're picking somebody that you trust, that is going to do a great job, but you're also not telling them that they have some big job they're going to have to do every day. It's really a break glass in case of emergency situation. And so it's naming an agent to step into your shoes to handle financial affairs when needed. So there's two different types. Well, that's not true. There's more, but one of the primary designations that people give is whether it's springing or whether it's durable and effective immediately. So springing only takes effect when you're incapacitated, and then a doctor signs a note or two doctors sign a note, maybe your family and a doctor, that say this person can't handle their affairs, or this person's laid up in bed and can't do it. And now all of a sudden that document springs into effect, and the agent that you named is able to jump in and help. The one that I typically do is effective immediately. It says that my agent walked out of this room right now with the document after I've signed it. They could go straight to the bank, and I trust them to help me and not do anything they shouldn't do. And then we make them durable, which says if I were laying in that hospital bed, that document is still effective. It's not voided by my incapacity. Once in a while, folks want a limited power of attorney instead of a general, or sometimes maybe even a financial institution will ask for that. And that is saying, you can handle my affairs in this specific category of tasks. My sweet, sweet neighbor, who's also a client, has been for a long time, but she goes abroad for months at a time to see her family. So every time she leaves, she asks me to redo that limited power of attorney that says that I can call her insurance company or, run over and try and put a fire out at her house if there is one. But she's very sweet about it. She just wants to make sure that it's limited. She doesn't want to burden me. So she doesn't want me to, have to worry about paying her bills. She just wants me to be able to transact regarding her house if there's an emergency. So you can be specific like that.
That's good. We had a question on power of attorney or beneficiaries. Like, is there a way to smooth the process for them? Can you give them documents beforehand? Should you give them your whole trust, for example? Or just, hey, this is where you can access my information and here's the login for it. How do you make it?
Yeah, with successors that you would have step in and help you if there was an emergency, crucial to at least let that person know that you've thinking about them having that job, or ask them whether they would, or put it on their radar to hey, you can find the documents here or with this advisor if something were to happen. We give clients, when we're done doing estate plans, kind of a fancy looking, embossed binder that has their name and such. That document, we don't, but we want you to put that somewhere where somebody could get it if it was an emergency. Some folks say, can I have 5 copies? I want to give 5 copies out to all of my children. And we say, okay, sure. But if you give out copies of something that you change later, it can either be confusing or it can be very awkward at Thanksgiving dinner. So think about the impact of, what if I give this to them and then I change my mind? That's not everybody's situation, but maybe for some reason it rings more true for me. I just tell folks, you might want to tell them you did it. I want to give them even like a little summary, but it's probably better to let them know they're in charge rather than just give them the document.
That's good.
All right, so next is, we talked about the power of attorney, and I know I mentioned this document earlier, but the next one, the last one, if you will, is the advanced healthcare directive, or as we called them in California until like 10 years ago, a power of attorney for healthcare. So your jurisdiction might still call it that. But just like you're naming that power of attorney to, in case of emergency, break glass, jump in and help me with finances, this one is jump in and help me with medical. Be my advocate, talk to my doctor's office, get records, be able to make that appointment for me, whatever it might be. And then when you start thinking about your person and your medical, you can see that actually gets pretty broad, right? So it goes from call the doctor to, okay, where am I going to live? Who's going to be the person that drops in and helps me if I need help and you're unavailable? Are you going to get the house cleaner? Are you going to get the caregiver? There's a whole bunch of area, mail, pet management. Those things all actually end up on our advanced healthcare directive. So there's all these different aspects and areas where that arises. And it's really important to make that decision while you can, set that up, have it in the binder, forget about it, or get your copy to your doctor's office and forget about it. And then that way, when you're in for foot surgery someday, you've already got somebody who can call and know exactly when you're getting out of surgery and all that. Doctor's offices are, they're okay, or hospitals are all pretty good about trying to get those records on file. But an important document to do, and another one that California publishes I said this already, but it publishes a very boilerplate version in the probate code, and your jurisdiction might too.
Yeah. Someone's asking some more questions on the POA. We have a couple of power of attorney questions. Should
Yeah.
you have like a backup in case, the airplane, whatever, or a car accident with your spouse?
Yeah.
And have you have a backup contingent?
Yeah. And not only that, but I like a continuity in those documents where you have a backup for your power of attorney. And that backup should probably be the same person who's your backup trustee. The trustee is a term that means the person managing the stuff, the financial stuff. And so you're the trustee usually while you're alive, and then you name a trustee for after you. And so I like the continuity of having your trustee who might be stepping in because you're incapacitated, or might be stepping in because you're now long gone. I like to be the same person. They're both financial jobs. And then, another financial job is, what if I had to have an executor anyway? If I had a will and I needed to have somebody be my personal representative, who would that be? I like that to be the same person. Those are all financial jobs and they all overlap. And so it seems like it's better, to me at least, to have the same person. Your healthcare person might be entirely different. I have folks kind of laugh sometimes in my office because they say, well, my daughter Karen, she'd be great at managing the money and managing the books, but oh my gosh, I don't want her making this decision whether to pull the plug or not. And that's, we all laugh, but that's a real thing. Some folks are, their skill set is different. Maybe they have those soft skills where they're great advocate and great helper around the house, but not the right bookkeeper, and vice versa. So doesn't mean that you have the same person making healthcare decisions, but I do like continuity with that power of attorney.
That's really valuable information. Someone was asking, and this might already be what you were talking about with the durable versus springing, but they were just saying, when does it kick in? When do you activate the POA with the doctor's note?
I like them to activate the second you sign them. And folks go, oh my gosh, they're going to leave with this power of attorney and go straight to my bank and they could take all the money. And I say, goodness, you probably picked the wrong person. Because if that's what you're worried about, let's name somebody else. Why do we trust them when you're laying in a hospital bed, but we don't trust them when you're actually have the ability to look out for what they're doing? So I like making them effective immediately, but they could definitely be springing. And that's definitely what some people are more comfortable with, and, to each their own.
That's good. Let's see. You probably, you may address this, but someone was asking again, is a trust better than the will? Do you have both?
So when we do estate plans, we always have, and the trust fits their need. Out here in California, how do I determine whether someone needs a trust? It usually comes down to, do you own any real estate at all, including your house? And if you do out here in California, it's financially worth it to have a trust. In other jurisdictions might be a little different. Might be other reasons to have a trust, even if you don't have a house, but those are generally the rule. You still have a will. And because, like we talked about funding your trust, getting your stuff into your trust, your will would typically say, I scoop up everything that wasn't already in my trust and I give it to my trust now. And in fact, that we colloquially call them pour over wills, meaning you gathered up everything else and you poured it over into your trust that you already had. And so it's a way to say, yep, everything I had is now going into the same place and is going to be dispersed according to the same set of rules, because you'll always acquire one more thing that's not in trust yet. You'll get a new lamp, you'll buy a new car, you'll, whatever, you'll open a new crypto account, and you'll need to put that in your trust eventually, whether you want it now or when you pass away.
That's good. Here's maybe the zinger question.
Oh,
don't know about, what to expect. You mentioned it's $50K, maybe more, if you don't have the cost, if you don't have just to do probate, if you don't have a trust or an estate plan in place. The cost to do an estate plan, probably the takeaway is probably less than what it's going to cost if you have to go through probate. They're kind of asking a cost question, maybe trying to figure out.
No, that's a really good question. And so it's 50,000 is an average. That's on $1 million gross value estate, which out here, $1 million gross value happens pretty quick, because you get your house that's, $750,000. Doesn't matter if it's got a $650,000 mortgage. They look at the 750, and then you throw in $250,000 of your retirement and other savings. Boom, you're at $1 million. That's 50 grand in fees, even with that big mortgage. For a joint complete estate plan. So that's when it's two folks and they're doing a complete estate plan. So they're not doing an a la carte, this document, that document. They're doing all of the documents. You should expect somewhere between 2,000 and 5,000 for that complete plan. Maybe a touch under that. Maybe the $5,000 price is a little bit more rare, but that's about what you should expect. Somewhere between 2,000 and 5,000. That's the range. The mean is probably a little closer to the 2 than the 5. For a single person, you should probably expect somewhere between 1,000 and 3,000. And again, that mean is probably a little under 2 normally. If you go online though, you can find services that, say it's $500, maybe it's $600 when you get all said and done. When I come to work, I drive over an overpass and there's a sign right there that says Living Trust, $399. So there is some services out there that will do it cheaper. But attorney prices is what I was referring to with those 2 to 5, 1 to 3.
Yeah, absolutely. We just have a lot of people saying, thank you, great content. They really appreciate it.
Yeah, my pleasure, honestly. Thank you for being here.
Time for one more question, Marcia, or are we done?
Yeah, we can do one more question. We might spill over a little bit, but.
Okay.
Get us a good one, Eric. Find us a good one.
Someone was just asking regarding just security of your stuff. Like, hey, if I choose a trustee, now are they just kind of able to take my stuff?
Yeah, they are.
Yeah.
Yeah, they are. Trust is so important here. I always made the joke back in the day. Well, it wasn't a joke. I meant it genuinely. I would say, well, you can name a bank because, a bank they're not going to steal from you. And everyone laughs and laughs and laughs when I say that. And I'm like, oh, no, I'm being serious. They're not literally probably going to steal your money. And so that is the concern always, is that you're giving a lot of authority and control to someone else. And that's why that person that you're naming is a fiduciary. Like Eric, like your fiduciary as well. Your fiduciary is somebody that has the highest burden under the law to think of your needs before theirs. So it's not even like, I'm thinking about you, but me too. It's, I'm thinking about you and then only me second. And so for that reason, in California, they have licensed professional fiduciaries. They have institutions that do this. There are lots and lots of recourses under the law for the fiduciary that steals or mismanages punitive things. You can have account values that just go down and you get charged by the court because you didn't do a good enough job balancing investments. So, yes, you're giving a lot of hope and faith and trust in another. But that's why it's a tough decision. You got to pick somebody who you trust. But we all have those people in our life. And if we don't, then we have them that are professionals that we can bring into our life. If we really think about it, it's not as scary as maybe it sounds.
Well,
Nice.
with that thought, we're going to go ahead and end. Eric, did you have one more thing?
Oh, no, people were just asking about the recording and things like that. You can speak to
Yeah,
that.
I'll go ahead and speak to that. To attendees, you can look to the link to the replay of this event. We will be emailing that out in the next day or so, and you're welcome to share that replay with your friends and family and rewatch it again for all that great content. We want to thank both Eric and Matthew for being here and for the organizations that have made this webinar possible today. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners is committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Well, once again, from Advice Chaser, thank you so much for coming, and we will see you at another webinar soon. Goodbye, everyone.
Thank you, everyone.